Hi everyone, and welcome to Business Law and Ethics. Today we're going to try something new. This is Tony Brancatella, and we're going to look at Chapter 6, working with contracts. And what we're going to do, why I'd like to do this, I always like to try something new, certainly, and different. But some of you have expressed your concern about lecturing and about certain items or certain information not being very clear. So I really want to make this clear for you going forward. So I will do as much as possible. I will videotape the actual class, or in this way you'll have it, or the actual lecture I should say, not the class. So you will have it in advance. And as you can see, I already posted quite a few different websites and YouTube videos that you can take a look at to gather more information. And I will be trying to do this as much as possible before class, so you'll have all this information, so it won't feel that the window of the class itself, meaning the time that you have to finalize it and get things done for the quiz, might be too tight. So this way, if you have any questions now, it's your responsibility. Since you're at home and hopefully you are social distancing and you are isolated and away from everything, we really need to get this virus under control. And the only way to do it is to follow the rules of the health minister and self-isolate or social distance. All right, so let's get into this. Learning objectives, you have them in front of you. Discuss the form of contracts, discuss electronic contracts. We're going to examine facts of contract relationships, for unenforceable agreements, consequences of breach of contract. We're going to examine the end of contracts and also punitive damages. So let's get into the statute of frauds. Right, the statute of frauds really requires that certain types of contracts be evidenced in writing to be enforceable. They need to be written down. So contracts not to be performed within 1 year, land dealings, guarantees, indemnities, and others all fall under the statute of frauds. So goods sold over a specific minimum, receipts or sales slips is enough in this case to declare that it is fraud. Promises of executor, in this case, personal responsibility for debts of an estate, or promises made in consideration of marriages also could be statute of fraud. So evidence has to be in writing, as I mentioned. Only the essential terms of the agreement, not the whole agreement, is necessary. Right? Is the contract void or unenforceable if not in writing under the statute? The contract is valid, not void, and is binding on the properties. However, the contract is unenforceable, meaning that the courts will not assist in enforcing it. All right, so this means it really has to have everything down in writing as much as possible. So guarantees and indemnities. Well, this is when creditors are not satisfied with the creditworthiness of a debtor. They may insist that someone, else also assume responsibility for the debt. Here again, it must be in writing and approved and signed by both parties. So guarantees, a third party incurs a secondary liability for the debt she has or he has given a guarantee. So the guarantor promises that if the debt fails to pay the debt, he or she will assume responsibility and pay it for them. Indemnities, on the other hand, describes a relationship in which a third party assumes a primary obligation, not a secondary, for the repayment of the debt along with the debtor. As a result, both owe the debt and the creditor can look to either for repayment. So if you look at certain differences here, pay attention to warranties or guarantees, damages are only, and must prove loss. On the other side, right, provide a guarantee compensation where a breach of warranty might not give rise to damages. We switch to electronic contracts in this day and age, especially more and more we go forward. Everything is going to be electronic, even more so with what's happening now. Everything is going to be certainly electronic, and even conversations and classes and so on and so forth. So electronics are really a big part of what we do in our life. So electronic records and communications have become more common. Less paper is certainly used. Electronic records can also be video. So many land registries create databases allowing lawyers to transfer property and register interests online. Some court documents can be filed online, not filled, or filled online too. Could be filed or filled online. However, still there are situations which request evidence in writing. In some cases, paper is still important and still lawful. The UCA, which is the Uniform Electronic Commerce Act, which governs principal information shall be denied legal effect or enforceability solely because it is in electronic form. No one, however, should be compelled to use electronic documents, and if you do, though, electronic signature is allowed. So this basically tells you that you don't have to be using this. When it comes to electronic forms, you can have a form that is paper. The other one that's very important to know is PIPEDA, Personal Information Protection and Electronic Documents Act. I did say along the way that I was going to tell you the differences between acts and laws, and what we're going to do is this is going to be done in the next class, but here you have an idea what it is. Acts basically adapt federal laws to the electronic environment, recognizing electronic documents and electronic signatures, provides specifically that electronic documents satisfy a requirement under federal law for a document to be in writing. So federal government, these are documents. This is nothing to do with provincial. Also, employees' main source of privacy protection is PIPEDA, so legislates how private sector bodies collect, use, disclose personal information in the course of a business. If we look at misrepresentation, it is a false statement of fact, misleads the other party and inducing them to enter a contract. It can be fraudulently, person knew the statement was false. Negligently, person should have known the statement was false. Due to exercise must be present. Innocently made without fault, and victim can use rescission. So it's important to know the difference because of the impact on the remedies to be applied on the interests of the parties. So rescission attempts to return both parties to their original position. The subject matter of the contract must be returned to the original owner, and monies paid under contract must also be returned. So in this case, damages are not available as a remedy because both parties are innocent. Allegation of fact, only statements made about the current state of things that prove to be incorrect can be considered misrepresentative. Promise to do something in the future will only be misrepresented if that person had no intention to honor the promise, I should say. A false statement, the misleading comment must be also incorrect and untrue. So a person tells the truth but withholds some information. So an example could be if a used car sales person tells a potential purchaser that the transmission of the car has just been replaced, but fails to say it was replaced with an old troublesome transmission. This partial truth can be misrepresentation if it leads the purchaser to believe a new transmission was installed, even if it was cleaned out and it looked clean or looked new, but it was not. Silence and non-disclosure. For misrepresentation to take place, there also must be some actual communication of information. In other words, silence won't heed here. So special situations where the person contracting is required to disclose certain information. Here, for example, insurance contracts require the parties acquiring life insurance are required to disclose if they've had something like a heart attack or other medical problems in the past. We come to duress and undue influence. Duress, a person is forced or pressured to enter contracts against their will. by threats of violence or imprisonment. Here, as you can attest or could imagine, it could be very difficult for one party to prove that the other party has created stress, has created duress, I should say, also. So here, some proof is needed. The more proof you have, the more chances are that you are going to be in the right. So undue influence, a person is under the influence and pressure of a dominant person. A relationship of trust is present. And on both cases, the contract is voidable. Again, here, to prove a person is dominant is something else also very hard to prove. Next one is unconscionable transaction. Here, doctrines that permits the court to set aside a contract in which one party has been taken advantage, pretty much the same thing as you just saw. So factors, desperation caused by poverty, where you take advantage of a certain situation. Gouging is another issue. Intellectual impairment, lack of sophistication. We see that today in and around where people are trying to take advantage of certain parts of our issue that we're in now, or with the lockdowns, and certain stores have to be closed, especially restaurants, and will probably lead to bankruptcy. They could be forced to sell to other parties for cheaper value than in the past. So this could be also considered to be a unconscionable transaction. So end of contractual relationships. Contracts can come to an end or be discharged by performance. Breach, agreement between the parties to end or modify, and frustration. So this is very important. Let's look at the four different ways a contract can come to an end. So here are the four ways. Discharged by performance. Contractual obligations are discharged and a contract is ended when both parties have satisfactorily completed their obligations under the contract. So tender of performance, a person is ready and able to perform a contractual obligation and attempts to do so. The other party refuses to accept it and prevents it. The first party is taken to have completed its obligation. It counts like if the contract has been performed, and the other party is required to perform its obligation too. If they don't, then the contract could be voided and discharged. It can also be discharged by breach. Involves a failure of the breaching party to properly perform its contractual obligations. A breach can take place in two ways: by improper and incomplete performance of the obligations and by refusal to perform. I can tell you that when I was in sales, we would have contracts with certain customers. And let's say we had one contract with a customer to supply every Monday at 8 o'clock a certain amount of product. And if we breached that and we're not capable of doing that, we had to advise the customer, and they were able to breach the actual contract and discharge it, I should say, and we're able to look for different suppliers in that case. Didn't happen too often, but it did happen. Discharged by agreement. Here again, parties agree to end or modify the contract. This is a bilateral discharge or mutual release. Both parties agree. That's what bilateral means. One side discharge can also be here when it's not disagreed. Contract may be still enforceable, and the other party can raise the defense of promissory estoppel, meaning that the promise was there for you to supply, and you went against the contract, and that could be an issue for that party. Discharged by frustration. When performance has become impossible, contract is considered discharged through frustration. Here, an example would be a firm was going to repair a bridge, but a storm washed away the bridge. Let's say contract to pay a house, but the house was destroyed by fire. It could also be that if a company decides to increase their volume and does promise to deliver a higher volume, but unfortunately their machinery does not come in time and they won't be able to supply, this could be considered to be frustration. If it was proven that the production machine was not delivered in time. Remedies for breach. Rescission deals with problems with the formation of the contract. Here again, it focuses on restoring the parties to their original position. You can start all over again. Rectification is another remedy, I should say. Interprets and corrects the terms of contracts if a contract was not done properly from the beginning or not satisfying to both parties after it started. You can change it. And damages to compensate a victim who has been misled or pressured into the contract. And last but not least, special, general, and punitive damages. This is when, if you look at the different ones, special damages, it's to cover specific costs. General damages to cover an estimate of what has been lost or will be lost. And punitive damages, rare circumstances to punish the offending party rather than compensate the injured party. And this can be a result of a higher award for one party. Great, so that's it for this, and you can take a look at it. And like I said at the beginning, you have it, so you can focus on this and help you to do the quiz, and you can use this information also for your final exam. Great. Hope to see you later. Take care.